Hi everyone, welcome to our webinar on protecting innovations in FinTech. We're just going to wait probably one more minute just while people are joining. The numbers are still increasing at the moment. So we'll just wait a short while, and then we'll get started. Okay, I think the numbers are fairly steady now, so we'll kick off with our webinar on protecting innovations in FinTech. So thank you all very much for joining us this afternoon. Just to introduce ourselves, my name is Pam Breyer. I'm a partner and patent attorney at Marks & Clerk. I'm qualified to advise in relation to UK, European and Singapore patents. We also have with us today, who will be doing some of the speaking, Tim Hargreaves, who's a fellow partner at Marks & Clerk and also a patent attorney qualified in the UK and Europe. And also Jason Chester, who is a qualified trademark attorney, also with Marks & Clerk. So to start, I'll just do a brief introduction to FinTech itself and why we're here. And then Tim will talk in more detail about patents in relation to FinTech, and Jason will talk in more detail about trademarks in relation to FinTech. And we'll take questions at the end, but if you have any technical difficulties or anything doesn't work throughout the webinar, please feel free to enter in the chat box and we'll attend to that. Thank you. Okay, so the FinTech market. Just to put some numbers on it, the market value in relation to FinTech was estimated around 127 billion in 2018. And interestingly, about 40% of that is considered to be in relation to North America. So they are by far the largest geographical area. But also Asia and Europe are quite big operators in the FinTech market. So there, at that time anyway, there was an expectation that we might see an annual growth rate of about 25% in the FinTech market. So it might rise to around about 300 billion by 2020. Of course, this might all be affected by the current pandemic. We don't know, like in most industries at the moment, exactly how this is going to play out and how it's going to affect things. Although you might think in some aspects, at least the FinTech market might be shielded a little bit from the impact of the pandemic, particularly when you look at things like the decrease in the use of cash and the increase in the use of digital payments instead. So in some ways, actually, maybe the FinTech market might benefit from some of the impact of the pandemic, but obviously we'll have to see how things pan out. In terms of who the players are in relation to FinTech, there's obviously traditional financial institutions and government agencies, but also quite a lot of big tech firms are operating in this space. So for example, the likes of Google, Apple, Amazon, Facebook, HP, IBM, and Microsoft are all really big players in the FinTech market, and really, although it's not their core business, it's related to obviously what they do, and they're keen to come up with innovative ways to facilitate payments and related financial technology. So we are seeing a lot of activity from these type of companies in this space of FinTech, as well as obviously lots of startups and more innovative small companies as well, and SMEs. In terms of patent trends, This is a graph showing the number of published patent applications globally relating to fintech technology. So this goes back to about 2002, right up till probably the end of 2019. And really it shows quite a steep rise at the start of that period, but then largely it's been broadly level for a number of years now, maybe with a slight dip a few years back. Possibly we're on start of an up curve again, although maybe it's just a leveling out still. But we're still looking at roughly 60,000 published patent applications in the area of fintech worldwide. So just a brief introduction on the types of IP and what we're going to be covering specifically today. So here is a list of many different types of IP. The two that are highlighted in blue, patents and trademarks, are the two main ones that we're going to talk about today. But there are also lots of other rights that may be relevant to your business and may even be more relevant depending on the nature of what it is you're doing in relation to fintech. So this is just a reminder that patents and trademarks, although we're going to focus on that area, there are other IP rights that might be relevant to your business as well. Okay, so now I'm going to hand over to Tim to discuss the patents in more detail.
Thank you. I will take control of the screen. So thank you to Pam. I'm going to talk about fintech and patents and the commercial value of protection. I'm sure everybody's aware that patents are extremely important for tech companies generally, can be the most valuable asset, and certainly for SMEs and startups, it can be essential to have patents in place in order to get investment. The same does apply to fintech, but there are some particular challenges when it comes to patenting fintech inventions, particularly in Europe and the UK. So my aim for the talk today is to give you a flavour of some of the issues we come across when we are dealing with fintech inventions, some of the challenges of getting patent protection in Europe. I'll talk a little bit about the different situation in the US, and then to try and tie it all together a little bit, I'll talk about patent strategy and adding the commercial value, because the whole point of filing a patent application is that it should be adding value to your business. So let's see if this works. Yep. So I'm going to talk, firstly, I'm assuming pretty much no knowledge about patents, so I'm going to give a really quick introduction to some patent basics. I'll then talk about some of the particular challenges of patenting fintech inventions in Europe. I'll say a little bit then about some hot topics. So AI and blockchain are hot topics really, particularly in fintech and AI across all fields, in fact. And there are some things to consider when it comes to patenting in those areas. I'll talk about patenting outside Europe, particularly the US. And then, as I said, I'll sort of loop back to patent strategy and commercial value. There's one slight health warning at the start. But firstly, when it comes to talking about patenting fintech, we do have to dig into some fairly detailed bits of patent law. This isn't going to be a law lecture, so I'm just really going to give you an overview and concentrate more on some examples of things that are and are not patentable. But I suppose the health warning is that this is definitely an area where there's no hard and fast rule. And if you've got an invention where you're considering patenting, you really do need to talk to a patent attorney. So someone like me or Pam can have a look at an invention and come to a conclusion quite quickly as to whether it's got a chance of being protectable or not. So it's worth bearing that in mind. It's not an area that's easy, and it does require consideration sort of case by case. So some patent basics. I'm sure people will know this already, but there's various different types of IP, as mentioned by Pam. A patent is intended to protect new inventions. Classically, we think of patents as protecting sort of widgets and engineering type inventions, and they can be used to do that, but they can protect a whole range of other things too. methods of manufacture, chemical products, pharmaceuticals, even software, which we'll come on to. There are many, many hundreds of thousands of patents granted for software inventions every year. They are also a particularly powerful right, even in comparison to some other types of IP. You get a 20-year monopoly right, and if you're protecting an invention which is core to your product and you can keep your competitors out, then that's something that's really potentially very valuable indeed. The flip side of this powerful right is that patents are very closely examined. It can take sort of 3 to 5 years to get a patent granted, and there are some very rigorous requirements. I need to mention novelty in particular. Key thing to remember, which I'm sure many people are aware already, but you can't publicly disclose your invention before you file a patent application. If you do, you might destroy the chances of getting protection. So even if you're discussing your invention in a meeting, it's important to make sure you have an NDA in place if possible, and or you restrict what you actually disclose. So it's not really a fintech point, but it's always worth taking the opportunity to mention that. So why file patents? I guess I've hinted at that already. Really, they have to have a commercial purpose. There's no point filing a patent application just for the sake of it. That purpose will vary depending on the position that you're in or the position your company's in. Many companies choose to build up patent portfolios without ever actually asserting them, almost as a defensive strategy. So in case anybody takes action against them, if one of their competitors sues them, then they can take action back. Some companies are more aggressive. They'll actually go out and try and litigate their patents and sue their competitors. For SMEs and startups who are very active in the fintech field, and certainly the offensive strategy is not something that's really worth thinking about too much. Certainly if you're an early stage company, the last thing your typical startup wants to do is start taking patent infringement actions, given the cost and the time it takes. But for companies in those positions, it can be key to have patents in order to attract investors. Certainly tech companies, one of the first questions an investor is likely to ask is whether you have patent protection in place. So this is actually really a real issue for companies of all scales. So what's the problem with fintech? Well, I said that patents are rigorously examined, and that's not just things like novelty and inventiveness. There are also some things that are considered not to be patentable. Now, in Europe, there are a variety of things, some of which I've listed here. And the key ones I've highlighted are methods of doing business and computer programs. Now, it's worth mentioning that it's those things as such, which we'll come back to, a slightly mysterious phrase. But clearly this does present a problem in fintech, because very many fintech inventions relate to exactly that. They relate to a method for doing business of some sort, or at least a method that's being conducted in a business context that's implemented as a computer program. So you might think, well, that means that's not a very hopeful start. Does that mean patent protection is not available? The answer to that is no. Patent protection may well be available, but we do have to look a little bit harder when it comes to fintech inventions than we do in some other fields. What we really need to be looking for is to see whether the invention is providing some kind of technical advantage or contribution, not just a business advantage. So even if your invention you think is relating to some key feature of a business process, when it comes to patenting, we have to look a little bit beyond that and try and find if there's some kind of technical advantage or technical contribution that's being provided, even though it's in a business context. So I will spend a few slides now talking a little bit about what we mean by technical, which is surprisingly difficult term to put limits on. This is really where I try and give you a flavour of the sort of things that are patentable or that aren't. When it comes to these exclusions, it is worth bearing in mind, before I sort of get stuck into that, it is worth bearing in mind with these exclusions that the law was drafted, over 40 years ago. And for example, in the case of computer programs, if you go back 40 years, many inventions were implemented as hardware or as mechanical or electrical devices, Whereas these days, computer programs actually are present in a huge range of different products where they never would have been before. So I mean, moving slightly away from fintech, but I think of the example of, say, a TV set. If you went back 40 years and you wanted to improve provide an improved TV set with maybe a cleaner picture, less interference, most likely you would be installing electronic circuitry, putting in some capacitors and inductors and so on. These days, it's much more likely that what you'll be doing is coming up with some clever smoothing algorithm that you're putting into the processor in the TV set. And it doesn't seem right that something that, because technology's moved on and it's now implemented as a computer program, it doesn't seem right that it shouldn't be patentable. And actually the Patent Office has recognized that. So the approach they take is they, even though the law says computer programs as such aren't patentable, what the Patent Office, certainly the European UK Patent Office, do is they look at what the program's doing. So in this example of a TV set, they will look at the computer program and they'll see that actually it's involving the control of a physical object, the TV set, and it's producing a useful, what they would call technical effect of smoothing an image. So even though it's a computer program, it's still patentable. So that kind of gives you a flavor of the kind of approach we take. Now, it still doesn't get us out of the woods when it comes to fintech inventions. As part of the problem is you look at a fintech invention and you'll see there's a computer program, and then you ask the next question, well, what's it doing? What's the effect that it has? Now, in the TV set example, it's straightforward. It's having a very clear technical effect on a physical object. The problem with fintech is the computer program may be having an effect on a business process. And then we look at the law, and the law says that business processes are not patentable. So we're slightly stuck. The situation is not quite as harsh as that sounds. In fact, all it means is we have to work a little bit harder to try and find that technical effect that we're looking for. So to give an example, a useful way to try and put this into real terms is to try and imagine, I mean, most inventions aren't just produced by a sole inventor, they're usually teams of people. And in fintech, you might have a collaboration between, say, an engineer or a software developer and a business person, or a trader or an executive or accountant, etc. One way to think of it is if the inventive features, if the clever bits of what you've come up with were contributed by the engineer, then it's quite likely you've probably solved some kind of technical problem. So if you, to give a real example, if you were working on a share trading platform, I mean, clearly the purpose of that is a business purpose, it's for buying and selling shares. But at the same time, the technical aspects are very important. If you can gain some kind of speed advantage on your share trading platform, or you can reduce the communications overhead, then you can have an improved system. And certainly if you improve the speed, then actually the trader might get an advantage in the trading environment. But it may be that to get that, you're solving a technical problem. So in this case, if the method was for trading shares, if there was some clever parts to it that reduced the communications overhead in the network, then that part of it might well be patentable, even though it's in a business context. On the other hand, if the ideas have really come from the business person and all the software developer or the engineer has done is just implement them in a routine fashion, then intuitively it's going to be a little bit less likely that you've solved a technical problem, and much more likely that you've really just solved a business problem. So a method for trading shares that minimizes the impact on the market price, that's just a clever trading strategy. Or a new algorithm for valuing a derivative product or some other financial product, that's not really a technical problem. It might be complicated, it might involve lots of hard maths, but it's not really solving a technical problem as such, it's solving a business problem. So actually there's an elephant cowering down at the bottom of the screen, which is perhaps unexpected, but it's really, we come back to this term technical all the time as patent attorneys. The problem is that we think of it's often mentioned that technical is kind of an elephant term. It's like, how do you define an elephant? Well, it's very, very difficult to do, but you know one when you see one. So it's really the point I was making earlier. If you've got an invention, it's really good to speak to a patent attorney, because the chances are they'll recognize the invention if they see it. But it's quite hard to define exactly what is sufficiently technical to be patentable. And again, this is really just to give, these aren't hard and fast rules on this chart. This is just to give an idea of things that may be more or less likely to be patentable. And as you'll see, some of these items are spread between maybe patentable, non-patentable, and patentable. It really depends on the particular invention and the context. But at one extreme, if all you're doing is automating a known business process, say you've got a mortgage processing workflow, and all you do is implement it in software. What used to be done by paper, you just implement it in software. I mean, it may take some effort from a software developer, but it wouldn't be patentable in Europe, because all you're doing is implementing on a computer something that was already being done. On the other side, if in doing that you come up with some new security improvements, new cryptographic arrangements, improved faster processing as part of implementing that, then it's possible that you might have something patentable. Or going back to the share trading example, if you've got a share trading platform and as part of that you're improving you're reducing the communication overhead, then it's more likely, even though it's a business context, you've actually solved a technical problem and it could be patentable. So there's no hard and fast rules, but there are some things that are more likely to have success and some things that are less likely to have success. Now, again, it comes back to this elephant test. These are really just listing. This is really just listing out some of the sort of the signposts that we might look for to think, well, do you have something that's solved a technical problem we might be able to protect via patents? Is it more secure? Does it process things faster? Less network bandwidth, etc., more efficient data storage. And it's worth bearing in mind that many of these issues are quite pertinent to fintech inventions. I mean, certainly when it comes to things like security, clearly that's something that's very important for fintech. And if you're coming up with new improved security arrangements, even though it's a business context, it may well still be patentable. Similarly, there are lots of high volume applications and large volumes of data and need for fast processing and so on. And if you can show you've done something clever technically to address those, then you may well have something that's patentable. So what does it mean? I think one thing to bear in mind is I've dipped into what's technical and what isn't, and I've dipped into computer-related inventions and software inventions. It is worth bearing in mind that there are lots of areas of fintech where this isn't too much of an issue. I mean, there are some things that in fintech that really are quite straightforward to patent. You know, ATM machinery, physical payment cards or devices, cryptographic apparatus. When we're getting down to the hardware level, it's potentially no more difficult to patent in the fintech area than any other general engineering type areas. What if the invention's purely in the software? Well, this is really what we've just been talking about. It does very much depend what effect the software has. So is it providing that kind of technical benefits, data security, authentication, hardware operation, etc.? It may well be patentable. Where it gets really tricky is the bottom bullet point. If it relates solely to a new business or administrative feature, or if we're just automating something that's already been done manually, for example, that can be very challenging. And it does involve a bit of detective work from the patent attorney and the engineering team to try and figure out, you know, even though on the face of it, it looks just like a business process, is there something underneath that you might be able to patent? If you do find something, you're left with the choice actually, because you might be in a position where you are maybe just protecting a small part of the system, and you have to take a view as to whether commercially that's important enough to do. But yeah, when it gets, there are some fintech inventions that are quite difficult to patent in Europe, without a doubt. I did want to say a little bit about AI and blockchain. I'll just tab down the bullet points. So these are both quite hot topics, and the European Patent Office in particular has issued reports on both these areas. For AI, machine learning, it's actually come up with some fairly detailed guidelines about what is and isn't allowable. Its starting point with machine learning and AI is that it's just a mathematical method. But you can make it patentable by applying it to a technical application in the first instance. So, for example, if you take your AI algorithm and apply it to an image processing task, then that will become patentable. So that the abstract maths behind it, not patentable, but as soon as you apply it to a technical task, it can be patentable if it's novel and inventive. As again with fintech, it's a little bit trickier, because if you're applying it to a business process, does that make it technical? Well, no, but you might be tackling some technical problems as part of that. The other thing the European Patent Office has identified is that a clever technical implementation or novel technical implementation of the AI process can be patentable in itself. And in some ways, this is a recognition of some of the technical complexity with AI. I mean, it is quite computationally demanding, requirements on memory and processors and so on. And if you implement that in a different way, regardless of what you're applying it to, regardless of whether it's fintech or image processing or anything else, if, say, you find a clever way to split your machine learning training across multiple processes in a particularly efficient way, or use multiple memories in a particularly clever way, maintain a cache of working data in a clever way, and so on. These are things that could be patentable, regardless of whether it's relating to fintech or anything else. And quite similar things apply to blockchain. So you're not going to get a patent very easily in Europe, if at all, if all you're doing, well, if you do get one, it's probably a mistake from the Patent Office part, but if all you're doing is taking known blockchain technique and applying it to a known business process, and the only thing that's different is you're using blockchain for its intended purpose, then you won't get a patent in Europe for doing that. But again, if you're applying it to a technical task, and then perhaps in a way that hasn't been done before, or again, if you're implementing it in a clever way, because blockchain again has quite, it's computationally intensive, and there are lots of technical problems around it, that if you're doing something in a slightly different way, even in a business context, then you might well have something that's patentable. So they're not enough in themselves to make a fintech invention patentable. Just because you're using AI doesn't mean you can get patent protection. But if you go beneath the bonnet a little bit, you might find that there are things there you can protect. It is worth mentioning protection outside the UK and Europe. So I've been talking, everything I've said so far pretty much has been concerning the approach taken by the UK and European patent offices. And these kind of criteria for patentability do vary between countries. The US in particular, if you went back 5+ years, 10 years certainly, then it was very easy to get patents for business processes in the US. This idea of worrying about technical effects and so on was not really an issue. You could get patents for a huge range of things in the US. They did tighten up a few years ago. There's a sign that it's coming back and becoming a bit more liberal again. I would say even at its tightest, in my experience, there were still things that were not patentable in Europe that were being patented in the US. So even if you can't get a patent in Europe, you may well still be able to get a patent in the US. And this is important. You might think, well, we're a UK startup, why does that matter? When you're thinking about your patent coverage, you do need to think about the commercial purpose. For one thing, investor may well still find some value in you having a US patent, but in particular, if you're thinking of expanding into the US in the next 5 years or 10 years, patents last for 20 years. If that's part of your business plan, then a US patent can be very valuable. The other thing is, if your business plan is, if your plan is that a big US tech company or a big US finance company hopefully comes and buys you out in a few years' time, that may not be your business plan, but if it is, then having a US patent is something that's could be very valuable. And also just the fact that it can be a bit easier to get the patent granted in the US. It almost gives you a bit of an insurance policy. If it's a bit borderline in Europe, is it worth investing in a patent? Well, maybe, but but at least you know that in the US you've got a bit more of a chance. Just very briefly, I haven't really talked about the process other than saying it takes a long time to get a patent, but there is an international patent system. And actually you can use that to defer the decision on the countries in which you file. So if you file a patent application now, if you use the international system, you can effectively defer the decision as to which particular countries you wish to cover for 2.5 years. And certainly for early stage companies, that can be really important. I mean, your commercial situation might be completely different in 2.5 years' time. And then I do want to say just a little bit about strategy, because it does take a long time to get patents and they do cost. I hesitate to say they're expensive because that depends what value you get out of them. I mean, if it increases the value of your company by 100 times, then it's pretty cheap, but they are a significant cost. So it is important to know why you're filing patents and what you're using them for. So it's important to have a strategy, and it's really important to keep it up to date. Now, it might be that your strategy is, well, we've thought about fintech patents and we don't think we've got much chance for our invention, so we're not going to file any patent applications, and that is a perfectly fine strategy. Then you have to also be thinking about other types of IP, so trademarks, which Jason will talk about, but also copyright in your software, trade secrets, keeping some of the things just secrets, not telling anybody about some of the magic things that you do that make it work well. And that's fine, and you can, as long as you can justify that to whoever might be interested, you know, so if you're looking for investment, if you can justify to the investor that we've thought about this and actually it doesn't work. Savvy investors will know that it's difficult to patent some types of fintech inventions in Europe, and that's perfectly reasonable. But it's important to have at least thought about it. So yeah, you really need to be thinking why you want these things. Is it worth spending the money and the time to get them? And as I say, for some software-based fintech inventions, do have a think about whether it's worth getting a patent in the US. Just one last thing about the process. I've said it takes a long time, and actually not just a long time to get to grant or refusal, maybe 4 or 5 years, but depending which route you take through the system, it might be 3 or more years before you actually have to start responding to objections from the patent offices. And you will get some early indications of what they think about the chances of success for your invention, but you don't actually have to start responding, possibly 3+ years, depending on the approach you take. So certainly if you're an SME or startup, you might want to be thinking, well, how does that tie in with your business plan? You know, is there any commercial value in having a pending patent application for the next 3 years, 2 years? I mean, I would say if there's no chance of getting it granted, then no. But if you've got some kind of business plan where you might proceed in the US a bit later, and it's useful to have something pending, then it's worth thinking about how it fits in with your strategy. And then the final point is really just to mention that it is important with this type of inventions, certainly if it's on the borderline, to talk to a patent attorney. And as part of the FinTech Festival, we are offering, I think it's next week, there's details at the end of the presentation, but some free IP clinics and consultations. So if, you know, bear in mind that we are available to talk through inventions. And the IP, in the UK, the IP audit scheme is very useful. So you can get very heavily subsidised initial IP advice. In Scotland, it's administered by Scottish Enterprise, but the IP audit scheme is worth, certainly for SMEs and startups, it's particularly useful. And I think that's me. I've just really given you a flavour of the boundaries of what's possible with patenting, and I'll hand over to Jason, who will talk about the importance of trademarks. I think that's it.
Thanks, Tim. Okay, hopefully that was a seamless transition. Can you see this, Tim?
That's good. Yeah.
Yeah, so this is a very brief introduction to trademarks. Typically, you would have a trademark portfolio that supplements your patent portfolio as well. But as Tim said, there are instances where it's difficult to obtain patent protection for the underlying technology behind innovations, in which case it does increase the necessity to make sure that you are obtaining trademark protection in different elements of the brand. So I'm going to start off just briefly talking about what a trademark actually is. Then I'll move on to the benefits conferred by trademark registrations, and then we'll just wrap up with just having a quick look at the types of signs which can be registered as trademarks. So trademarks are a registered IP right that protects the distinctive components of a brand. So we're talking the components of a brand that can communicate information about the origin of the goods and services that are being offered by a company. So it's similar to patents. It's a negative right. It confers an exclusive statutory right to prevent others from using either an identical or confusingly similar mark in relation to identical or similar goods and services. Trademarks which have developed a reputation have broader rights. So in instances where a trademark registration has a reputation, the registration can also provide a mechanism to prevent others from taking unfair advantage of or causing detriment to the distinctive character and/or reputation of the trademark. Like patents again, trademarks are territorial in scope. So the general rule is the registration is limited to a specific country. However, there are some exceptions to that rule. There's, for example, an EU trademark which confers protection in all 28 member states of the EU as it currently stands through a single registration, but that will of course end when we get to the end of the transition period on the 31st of December, and the EU shrinks down to 27 member states, and the UK will be a separate system. So patents typically last for 20 years. Trademarks can potentially last forever, provided that they're renewed, typically every 10 years, and provided that they're still in use. They're also an intangible asset, and they can potentially accumulate value, and they can be sold. They can form the basis of a license agreement, and they can even be used as security for lending. So what's not a trademark? We often get startups coming to us saying, well, I've registered a company name. A company name's not similar to a trademark at all. It just secures the company name and stops third parties from getting registration for an identical company name. But it does not confer any rights for you to prevent someone using a similar trademark based on that company name. So it's a good idea to seek trademark protection for a company name where goods and services are being sold under it. Domain names as well, they just secure the domain name and do not confer trademark rights. They do not in themselves entitle the owners to use the domain name in a trademark capacity. So just because you have a domain name registration, it doesn't mean that you're actually able to use the distinctive element of that domain name. A third party could potentially have trademark rights in that distinctive element and potentially bring infringement proceedings against you if you're using that element in a trademark capacity. Descriptors as well. So there's often a bit of a conflict between the marketing perspective and the trademark perspective. So from a marketing perspective, businesses typically want to instantly inform consumers exactly what goods and services they're offering. So they typically adopt brands which describe a characteristic of the goods and services. However, from a trademark perspective, you want the complete opposite to be the case. So typically, generally speaking, the further removed from the goods and services the trademark is, the better rights it can confer and potentially the broader monopoly that you can obtain. So a descriptor, it typically provides consumers with information regarding the characteristics of the goods and services. So this is a non-exhaustive list, but it includes the nature, kind, quality, intended purpose, geographic origin, value, or quantity of the goods and services. So the benefits, as any form of IP, the most important benefit conferred by protection is control. So the trademark registration will provide you with a basis to prevent or control, by way of license agreement, for example, third-party use of an identical or confusingly similar mark. It is important to note that that's going to be typically limited to the jurisdiction in which you have the registration. It also secures a filing date, so it prevents third parties from being able to file a identical or confusingly similar mark that could potentially be used to block your use and later attempts to obtain registration. So as soon as you file the application, provided that the trademark remains valid, that filing date is secured. So if you launch a brand, a third party in that particular jurisdiction can't just swoop in and file an application. If a third party does get in there first and file an application that predates yours and you've not got any use, it can cause problems. They can potentially use that as a basis to prevent you from being able to use or later attempt to register the trademark. One of the most important benefits conferred by a trademark registration is it enables you to bring infringement proceedings, which generally speaking, it provides more legal certainty than the common law tort of passing off. So in the UK, for example, unregistered rights are recognised, and where you have sufficient goodwill, it is possible to bring a claim of passing off against a third party. However, this is an evidence-based claim, so it can often be very costly to put it together, and also it doesn't give you as much legal certainty as infringement proceedings based on a registered trademark. It's also important to note that in some jurisdictions, unregistered rights aren't recognised, so China is a good example of that. And as discussed earlier, so for trademarks with reputation, the registration can prevent third parties from using or registering identical similar marks that are likely to take unfair advantage of or be detrimental to the distinctive character or reputation of the registered mark. So where a trademark has a reputation, it effectively gives you a broader scope of enforceability. And even if third parties are using a similar mark in respect of dissimilar goods and services, if consumers are still going to make an association between that mark and yours, you can potentially stop them from using the mark. And as discussed earlier, it's a property right that can accumulate value. So a brand can sometimes be the most valuable asset owned by a company. So for example, Apple was valued at 206 billion by Forbes back in 2019. It can add value to the business, and it can also encourage investment. When you're looking to secure investment, investors will typically conduct some due diligence into the IP owned by your business, and typically they'd want to see that you've got the brands protected, and also you're able to use the brands as you've conducted appropriate due diligence yourself by conducting appropriate trademark searches. Trademarks can also be leveraged to negotiate coexistence with third parties. Given the territorial nature of trademarks, you could potentially own earlier rights in some jurisdictions, and a third party may own earlier marks in other jurisdictions, and that can potentially give you some leverage to negotiate some form of coexistence. It can also act as a deterrent. So when usually before someone will look to register a trademark, they're typically conduct a trademark search in the first instance. If you've got a registration, it's going to be highlighted in that trademark availability search, and it may put off the third party from adopting a similar brand because of the perceived risks. Also, if you've got a trademark registration, you can use it in combination with the R in a circle symbol, and that can again act as a deterrent and put third parties off from replicating it. It can also provide you with a basis to challenge identical and confusingly similar domain names as well, which is very important considering that in the fintech industry, there have been quite a few cases of cyber squatting, whereby third parties have registered similar domain names, typically to high street banks, in an attempt to try to give consumers the impression that they're the real thing or affiliated with them. So having a trademark registration will give you a basis to be able to challenge those domain names. So what can be registered? So there's no surprises here. Traditional trademarks, traditional elements of a brand which can be registered. So you've got the word elements. Also obtain trademark registrations for stylized words which aren't appearing on here for some reason. have to use your imagination. Logos as well. So for example, the Starbucks logo, that's a registered trademark. Composite marks as well. So depending on the brand strategy, you may just want to have a single registration for word, stylized, and logo elements together. Although generally speaking, it's better to have separate registrations for word and logo elements if both elements have their own individual distinctive character, as it just enables you to be strategic when it comes to enforcement, and you can pick whichever marks share the most similarity with the third-party mark when bringing enforcement actions. And slogans as well. You can potentially get a trademark registration for a slogan. Generally speaking, slogans have to satisfy a higher threshold, as they're typically perceived by consumers as promotional statements rather than trademarks, rather than badges of origin. However, if the slogan does have some kind of distinctive feature to it, then it will satisfy the requirements. So in addition to the traditional trademarks, there's also elements of brands which you may not be aware, may have not been aware of being able to protect. So in instances where colours have acquired distinctiveness through use, it is possible to get a trademark registration for the colour, and that will protect the colour applied in different ways. It's also possible to protect the shape of products. Again, usually can sometimes be difficult, as shapes aren't generally perceived as trademarks, so it does have to have some kind of independent distinctive character. Patterns as well. You're probably not going to get a trademark registration for a pattern straight away. You'll probably have to acquire distinctiveness through use. It's also possible to protect the position marks. So this protects the color and the position of this mark by reference to the product. There's also motion marks. So there's one from Toshiba there. So that protects the whole feature of this, and multimedia marks, which is a combination of the motion and sound. Sounds as well. And holograms, which can be very useful for enforcement purposes. And there's also the possibility, provided that they've got sufficient distinctive character, to protect smells and taste. So what can and can't be registered? So as I said, the trademark has to be distinctive, so it has to enable consumers to be able to identify goods and services as originating from your business as opposed to a third party, and enable them to distinguish the origin of your goods and services from those of third parties. So marks which can't typically be registered are non-distinctive marks, descriptive and customary marks. There is a caveat to that though. If they acquire distinctiveness through use, it is possible to satisfy the requirements for registration. So provided that you have conducted searches in the first instance, just to make sure you are able to use a particular element of the brand. If you're looking to adopt a fairly non-distinctive brand, it is good practice to use it in combination with the TM symbol, because when you try to register it later down the line, there's an argument that you can put forward to say that you've taken steps to educate the consumer that's being used in a trademark capacity rather than a descriptive term. So the acquired distinctiveness caveat doesn't apply to shapes. So this is the case where the shape results from the nature of the goods themselves. So for example, if you wanted to get a trademark registration for the shape of an orange in respect of oranges, a shape which is necessary to obtain a technical result, because this protection is suited to patents, and a shape which can give substantial value to the goods that you're looking to protect. And then there's various other provisions, various other bars to registration. So just a few tips when coming up with a new brand. It's important to think about what aspects of the brand you'd like to protect. Are the elements of the brand that you're looking to protect sufficiently distinctive to satisfy the requirements for registration? If you're looking to register in multiple jurisdictions, it's important to bear in mind that the practices may differ, so it's important to obtain advice early on. And it's very important to conduct trademark searches. When you're applying for a trademark application, it's published for opposition purposes, and this will give third parties an opportunity to oppose the application if they feel it's too similar to an earlier registration of theirs. The opposition provisions typically mirror the infringement provisions, so if a third party's got a good basis to oppose the application, we also like to have a good basis to challenge your use by way of infringement proceedings. So although searches can be fairly, they can incur some expense early on, it's much better to conduct this due diligence at an early stage and be able to assess the risks that are out there rather than launching a brand and investing the time and money in developing it only to find that there's going to be a conflict with a third party. So trademark strategy needs to align with your business plan. So it's not possible to obtain a single trademark registration that covers the whole world. You've got to be strategic with the countries or territories in which you have the trademark registration. So you need to think about where you're going to be selling, exporting, or manufacturing the goods, which manufacturing the goods isn't obviously going to be too much of an issue for fintech. Sometimes you may want to have a think about where you're likely to be infringed or where your competitors trade. So there are certain jurisdictions where infringement happens a lot more often. So China is an example of that, where goods and brands are typically counterfeited, copied. And it's important to ensure that you own the IP as well. So copyright will automatically subsist in different elements of a brand. So for example, a logo. So it's very important before you apply for a trademark to ensure that the ownership of the copyright is assigned to you. This is very important when you're commissioning a third party like a branding agency to create a brand for you, as they will typically be the owner of the copyright, subject to any agreement to the contrary. And that's it. So it's a very quick whistle-stop tour of trademarks, and that leads us on to questions.
Thanks very much, Jason and Tim. Yes, we're free to take questions now. I think we've got about 10 minutes or so. A few questions have come in so far, so we'll go through those. But if anybody else has any other questions, feel free to type them in now. And also, as you'll see from the screen, we will be holding a virtual IP clinic next Tuesday. So if you would like to speak to one of us or one of our other colleagues about a specific IP matter that you've got, we'll send you details after this as to how to register for that, and hopefully we can address your concerns there. But I'll go through the questions we've got at the moment. The first one is quite long, so I'll paraphrase a little. So it relates to blockchain, and it says, is common practice for blockchain technology to be subject to open source licensing? The argument is that the program would then be subject to peer review and collaborative development. But really, I think the question is, in order to adopt a defensive patent approach, it seems reasonable to apply for a patent. Is it common practice to insert in text within the patent to indicate that it is being sought to protect the idea from being claimed by someone else? Without such a claim, the collaborative fintech community may be left wondering whether a party acquiring the patent in the future may subsequently seek license fees and attempt to enforce the patent. Tim, do you have any views on that?
So I mean, I guess the short answer to the question about inserting text into the patent to indicate sort of benign intent, I suppose, is no, actually. I mean, I don't think I've ever come across a patent where there's been some indication given in the patent application itself that that it's not intended to be enforced, for example. It's quite an interesting point, though, because patents are tools, so it really depends. I mean, they can be weapons as well, but they you know, how you use them is up to you. Just filing a patent is not in itself an aggressive thing to do. I mean, you can you can file a patent application, but then actually make it, you can freely license it to anyone who asks for a license, for example. And there are sort of open licensing models out there that people, universities have attempted, and so on. So the answer is no. I've never seen the case where text is put in a patent application itself. But of course, if you want to make your benign intent known to interested parties, then there must be other ways of doing that. I mean, you can make it clear that it's free for licensing, etc. I mean, one reason for not putting text like that in is that I mean, patents last for 20 years, and also the text we put in initially survives throughout that 20 years. You know, it's always on file. So it's almost mixing two things together. How you choose to use your patent is a separate thing, and you can use it benignly or aggressively or in a whole range of different ways. But you wouldn't usually put any text in the patent itself.
Yeah, I mean, there are other ways you could publish your idea as well to prevent other people from patenting, if that's the main concern. There are specific mechanisms that you can use in order to publish something. So it's effectively deemed equivalent to a patent filing just for publication purposes, and it will be searched in future by examiners if someone does try to patent something similar in the future. So that might be something you could look into as well on that front. Okay, we're running a bit short of time, so I'll just run on to the next question. What are the implications of filing a patent in the UK or EU but not doing so in the USA? Is there a potential that someone else could patent roughly the same concept in the USA? Tim, I guess that's for you again.
One of us. I'll start, then you can finish. That's a good idea. So I mean, again, it's a good question. So one thing I didn't really mention in the talk, because I didn't want to sort of do a whole patent basics thing, but patents are territorial. So if you get a patent in the UK, it just protects you in the UK. You can't use it to stop somebody using your invention in the US or manufacturing the same invention in the US, for example. It would be difficult. So if you just have a UK patent, you can't stop someone using your invention in the US. However, it would be difficult for them to actually then go and patent in the US the same idea, certainly once it's been published, because this, I mentioned the sort of strict novelty requirements. And actually, once your application's been published, it would be pretty much impossible for anybody else to patent it in any other countries, because you've already published it. So it's what we call prior art. So any patent filed later would not be novel over that publication. The publication only happens after 18 months. So you can get in a situation where, you know, it only comes to light after 18 months that actually somebody else has patented something very similar to you. And then in most countries, it becomes a bit of a battle as to who filed the patent application first. The situation in the US used to be a bit different, but now the US is much more similar to most other countries. And actually the key thing is who filed the patent application first. So I wouldn't worry too much about filing a patent in the UK and then somebody sort of then subsequently seeing it and filing it in the US, because to have seen it, it will have to be after it's published. And once it's published, it would stop the US patent being novel. But you certainly can get in a position where two or more people are patenting quite similar things around the same kind of time. And then it's a question of who files the patent application first. So that is one reason, if you are going ahead with a patent, patent attorneys were always very concerned about the filing date. We always want to get the patent filed fairly promptly. You don't want to leave things hanging around too long, because the filing date is actually very important. But in summary, if you file in the UK only, you can't stop someone using your invention in the US, but it's pretty unlikely they're going to be able to patent it in the US.
Thanks, Tim. Just one last quick question, because we're almost out of time, and it concerns the IP audit scheme that Scottish Enterprise were running, and in fact other similar bodies were running in other parts of the UK as well. Jason, do you happen to know if that scheme is still available and if they will still contribute to your costs?
I think so, but I'll pass this over to Tim because I know that he's.
As it happens, I've done so. They renew it in April each year, and I did get a new one come through in May. So yeah, so on that basis, yes, they are. I did speak to someone at Scottish Enterprise at the time, though, about the scheme, and they said that actually the funding's been reduced quite a lot. So it sounded like they maybe had a third the number of IP audit funding packages available compared to previous years. So it's gone down by 2/3. And it always used to be that, so we do quite a lot of them, and it used to be the case that it was pretty rare that people got turned down for them, at least the ones that we saw. Whereas I think now it's probably, I think if you apply for the IP audit funding, there's no guarantee you'll get it just because the numbers have reduced. But they are still maintaining the scheme.
Okay, thanks very much. I think that's probably all we've got time for, so I think we'll wrap up there. So thanks again to all our speakers, Jason and Tim, for your contribution, and thanks to the audience as well for making the time to watch this webinar. Bye for now.